Mhm, mhm. All right, let's see if this will work. Hi, how you doing? It's good to hear. I am stuck on this one question for my business law class. I just want to see if you could, perchance. Okay. So I'm supposed to make like an outline, and I can't seem to remember off the top of my head. Outlines are typically written in what letter format? Okay, I see here. All right, so they're Greek letters. Okay. So they have like an article here, and I'm trying to figure out the best way to write an outline for it. So, oh, here we go. Introduction to managerial duties and business law. Okay, one second here. Used about formatting. I don't want it to be underlined. Introduction. Okay, and then I'm supposed to put letters in, I believe, after Roman numerals. Yes, it's correct. Okay. All right. So it says here, this note consists of excerpts from Principles of Corporate Governance, Analysis, and Recommendations. Uh, a set of legal guidelines assembled by the American Law Institute in 1992, because the principles reprinted here are far more comprehensive, and because actual business law varies from state to state, the contents of this note should not be used as legal advice. Uh, so that's basically saying that the written text is not legal advice. Okay. Okay. All right. Letter B. These principles do, however, provide a general outline of managerial duties that approximate the intent of business laws in effect throughout the U.S. The text is divided into black letters. The succinct statement of various duties and principles, each of which is numbered, and comments which explain the import and proper interpretation of the black letter. So, what are they trying to say there? What do you think? Wait, so they indicate the sections of rules and laws? No, sections. You were saying that they indicated sections. All right. Uh, Okay. Uh, what else do we have here? All right. Well, I think that's it for that section. Let me see. Next one states here, I guess this is fiduciary or Fiduciary. Fiduciary? Wait, say that again. There's a position of trust. Okay, 1 second here. One second here. Service. All right. See the objective and conduct of the corporation. 1 second here. I just had trying to figure out what this is saying here. Here we go. Okay, you were saying with the objective and conduct of a corporation. Okay. And the conduct is the manner in which you behave to achieve it. So that again, you say was the manner of which the corporation. It's the objective of what the corporation is trying to achieve, produce. Right, right. And the conduct is the manner of which the corporation. How it will behave, to high standards and all that. All right. Let's see here. Uh, it says here, subject to the provisions of subsection B. I don't know what that's referring to. And Penal Code 6.02, action of directors that has the foreseeable effect of blocking unsolicited tender offers. I'll read this one more time. Subject to the provisions of Section B, I don't know what that's referring to. And then Penal Code 6.02, action of directors that has the foreseeable effect of blocking unsolicited tender offers. A corporation should have its objective the conduct of business activities with a view to enhancing corporate profit and shareholder gain. So they are secondary in receiving. Okay. Oh, say that again. You were breaking up. Okay, now I hear you. You said the interest of the board of directors. Okay. Let's see what's next here. Uh, even if corporate profit and shareholder gain are not thereby enhance the corporation in the conduct of this business, is obligated to the same law extent as a natural person to act within the boundaries set by law. So what is that saying? That read that one more time here. Even if corporate profit and shareholder gain are not thereby enhanced, the corporation, in the conduct of its business, is obligated to the same extent as a natural person to act within the boundaries set by law. So, right. Okay. Right. Okay. So let's see here. So that's good. Then it has here company may take into account ethical considerations that are reasonably regarded as appropriate to the responsible conduct of business. Companies may take into account ethical considerations that are reasonably regarded as appropriate to the responsible conduct of business. Okay, so companies. Okay. Uh, One second here. Okay. Um, Proper. Companies may devote a reasonable amount of resources to public welfare, humanitarian, educational, and philanthropic purposes. Okay, one second here. So companies can. Okay. All right. One second here. All right, corporate objective and conduct. The subject matter of these principles is the governance of business corporations. The business corporation is an instrument through which capital is assembled for the activities of producing and distributing goods and services and making investments. These principles take a basic proposition that a business corporation should have its objectives to conduct such activities with a view to enhancing corporate profit and shareholder gain. Uh, this objective, which hereby be referred to as the economic objective, is embodied in subsection A. The basic proposition is qualified in a manner stated in subsection B, which refers to the conduct of the corporation. Uh, the provisions of subsection B reflect a recognition that the corporation is a social as well as an economic institution, and accordingly, that its pursuit of the economic objective must be constrained by social imperatives and may be qualified by social needs. So that's all saying that corporate. Okay. Right. Right. Um. Okay, so that's what that's saying there. Then it says here, okay, the economic objective. Okay. Uh, right, the economic objective of a corporation. Here it says, in very general terms, subsection A may be thought of as a board injunction to enhance economic returns, while subsection B makes clear that certain kinds of conduct must or may be pursued whether or not they enhance such returns. That is, even if the conduct yields no economic return or entails a net economic loss. In most cases, however, the kinds of conduct described in subsection B could be pursued even under the principle embodied in subsection A, which conduct. So, what is that? So, what was that term you said? Companies have to behave as a proper entity or community. What's it called? All right, so that's that. What else do they have here? Such conduct will usually be consistent with economic self-interest because the principles embodied, uh, subsection A, that the objective of the corporation is to conduct business activities with a view to enhance corporate profit and shareholder gain, does not mean that the objective of the corporation must be to realize corporate profit and shareholder gain in the short run. Indeed, the contrary is true. Long run profitability and shareholder gain are the core of the economic objective. Activity that entails short run costs to achieve an appropriately greater long run profit is therefore not a departure from the economic objective. An, an orientation toward lawful, ethical, and public spirited activity will normally fall within this description. The modern corporation, by its nature, creates interdependencies with a variety of groups with whom the corporation has legitimate concerns, such as the employees, customers, suppliers, and members of the community in which the corporation operates. The long term profitability of the corporation generally depends on meeting the fair expectations of such groups. Right. So, all groups of the community surrounding the corporation is to be, um, or actually are to be, okay. Right. Right. Let's see here. Um, let's see. Short-term profits may properly be subordinated recog- to recognition that responsible maintenance of these interdependencies is likely to contribute to long-term corporate profit and shareholder gain. The corporation, uh, short-term profits may properly be subordinated to recognition that responsible maintenance of these interdependencies is likely to contribute to long-term corporate profit and shareholder gain. Not exactly. So that right. Right.
So you've got to set up an intelligent program to maintain all the components of the corporation that are necessary for it to function well. So first, you have to have pay your line workers, people who are making the stuff. You got to pay them. You can't pay them minimum wage if it takes a certain amount of skills. You can't put all the money into the executives and starve the rest of the people.
So you're saying intelligent programs are needed to be put in place to maintain proper
Proper balance of salary and retirement planning and insurance and all those things. And the building's going to wear out after a while, and equipment wears out. If you haven't set aside some money to buy a new machine, then when one of them breaks, you just lose money. And you have to pay your taxes.
right.
So anyway, you just have to have a proper budget and business plan that services all the people within the corporation and makes and provides the corporation, allows the corporation to be a good citizen in the community.
All right. Let me see what else here.
So this is making sense to you, right?
Right.
Okay.
Let's see. For corporate reasons, I think I might have just read this. The corporate reasons, the economic objective does not imply that the corporation must extract the last penny of profit out of every transaction in which it is involved. Similarly, under normal circumstances, the economic objective is met by focusing on the business in which the corporation is actually engaged. Uh, Although a corporation decision maker needs to meet a standard of care in making decisions, that standard can be satisfied even when, as is often the case, a prospective profit cannot be particularized. Recurring instances of this sort include those in which the object of a corporate action is to maintain the confidence of business organizations with which the corporation deals, to foster the morale of employees, or to encourage favorable or forestall unfavorable government regulation, as by abstaining from conduct that would engender unfavorable public reaction against the corporation, providing lawful assistance in connection with lobbying or referenda activities, or voluntarily adopting a course of conduct so as to forestall legislation that would instead mandate such conduct.
All right. In other words, you have to be a good citizen. And if you're not being a good citizen, they're going to fine you or penalize you or shut you down.
Right.
Another example of that is you can't take all the production waste and dump it in the river.
Right.
And then somebody down the river will worry about it. You can't do that.
Right. Let's see what else.
Which is like we have done before.
Right. Uh, I'm gonna skip some here.
You seem to have a good grasp on this.
Corporation. Thank you. Let's see what else we have here. Okay, here we go. Section 2.01. I'm not sure what that is referring to. Provides that a corporation may take into account ethical considerations that are reasonably regarded as appropriate to the responsible conduct of business. It is sometimes argued that because adherence to ethical principles typically involves long run financial benefits, the concept of the long run dissolves any apparent tension between financial and ethical considerations. Certainly,
Yeah.
a long run profit motive may often explain conduct that appears to be based on ethical grounds. Furthermore, when ethical considerations enter a corporate decisions, they are usually mixed with rather than opposed to long run profit considerations. Nevertheless, observation suggests that corporate decisions are not infrequently made on the basis of ethical considerations, even when doing so would not enhance corporate profits or shareholder gain. Such
In
behavior.
other words,
So, ethical considerations can reduce profits. However, they are necessary, necessary in good citizenship or in providing good citizenship or okay. What else here? All right, moments here. Writing a note here. One moment here. Okay, duty of care and the business judgment rule. Uh, the relationship between duty of care and duty of fair dealing. The legal obligations of directors and officers have traditionally been divided into categories of duty of care and duty of loyalty. The latter is referred to in the following section as the duty of fair dealing. The Corporate Director's Guidebook properly distinguishes between the two as follows. Um, Duty of loyalty: by assuming his office, the corporate director commits allegiance to the enterprise and acknowledges that the best interests of the corporation and its shareholders must prevail over any individual interests of his own. The basic principle is to be observed is that the director should not use his corporate position to make any personal profit or gain other personal advantages. And then,
In other words, self-enrichment
okay, so
at the expense of the corporation.
okay, so write down here, executives shall not make what's it called, profits.
Decisions affecting profits.
Okay, one moment here. Okay, and then let's see, second thing here. Uh, duty of care. In addition to owning a duty of loyalty to the corporation, the corporate director also assumes a duty to act carefully in fulfilling the important tasks of monitoring and directing the activity of corporate management. Let's see here.
You need to make sure everybody's doing what they're supposed to be doing. Not being inefficient or wasteful or illegal or substandard, I guess.
All right. Let's see here. Neglect, mismanagement, and intentional decisions to do wrongful acts as are dealt with in the duty of care and business judgment provisions in this section. Uh, they have some of the stuff very strangely written.
Yeah.
But fraud, self-dealing, misappropriation, or corporate opportunities, improper diversions of corporate assets, and similar matters involving potential conflicts.
Such as taking some of the corporate money, building a house for you to live in.
Right. Basic approach. Historically, courts, rather than legislatures, have played the central role in shaping the law regarding the duty of care of corporate directors and officers. In the past 25 years, however, over two-thirds of the states have enacted statutory provisions concerning the duty of care. Uh, this section articulates the duty of care obligations of directors and officers. Uh, It should be emphasized at the outset, however, that these are general legal standards and that their application in most instances will involve subtle evaluations of specific facts and circumstances. Let's see here. Directors and officers obviously should not be required to ensure that every potential corporate problem is anticipated or that every instance of wrongdoing is prevented. Right. One moment here. So I'm gonna write a note here. Executives um, are not able to always be in check, or not be in check. What's it called? Be in what's it called? Be in knowledge, I guess, or be. I guess be aware.
Read what you have.
So what I'm trying to write is that executives are not always able to be.
Anticipate outcomes.
Oh, 1 second. Always anticipate outcomes, and that by this standard that they are not legally liable for okay. Uh, let's see here. Special note should be taken of the application of duty of care standards to business judgments under the judgment rule. Uh, see, shareholders accept the risk that an informed business decision honestly undertaken and rationally believed to be the best interest of the corporation may not be vindicated by subsequent success. Right.
Sometimes you try to do something and it just doesn't work.
Right.
People don't want purple shirts.
Right. Let's see here. Finally, it should be remembered that in large measure, directors and officers properly carrying out their functions because of motives unrelated to their legal obligations, including a personal sense of responsibility, economic and career incentives, pride, professionalism, peer pressures, and a discipline instilled by competitive markets and tender offers. For for well over 100 years, however, courts and legislatures uh, have considered legal standards with respect to duty of care to be a necessary protection for corporations and their shareholders, as is true of professionals and almost all others in society. The accountability of directors and officers is a legitimate public policy concern. Um, right. Let's see here. So the business judgment rule. Uh, uh, the biz the business judgment rule set in place for corporations to follow. Uh, a director or officer has a duty in the corporation to perform their director's or officer's function in good faith. in a manner that he or she reasonably believes to be in the best interest of the corporation, with the care that is ordinarily prudent person would reasonably be expected to exercise in a like position and under similar
Right.
circumstances. Uh, let's see.
Yeah, that makes sense.
Let's see. The duty includes the obligation to make or cause to be made an inquiry when, but only when the circumstances would alert a reasonable director or officer to the need therefor. Uh, the extent.
So if you fail to act like a reasonable person, then there's something wrong. What that's saying is you should behave as a reasonable person within the position that you're in.
Okay. Okay. Let's see here. Oh, give me 1 second here. I might have to call you back in a couple minutes. Yeah, my phone is to charge here. Sure. I might call you maybe perhaps like 5, 10 minutes. Sure. Talk later. Bye now.